A very good afternoon to everybody here. Thank you so much, students, for being part of this journey. Today, we are going to have our last and final session of the Student Innovator Program 2025. I'm sure you're excited to learn what's going to happen today. But we're also going to let you know at the end of the session what you have to do going forward. हम आपको बताएंगे इस सेशन के एंड में कि आपको आगे क्या करना है, तो ये प्लीज एंड तक सेशन में रहें and be as involved and as participative as possible. Make the most of this opportunity today. Today is the last session, and for that we have a very special guest, Dr. Molly, who is the CEO of Atal Incubation Center SKU, who is going to be who's going to be walking you through the intellectual property rights session. Thank you so much, Dr. Molly, for being here with us.
Thank you.
I hand it over to you to take it forward, Dr. Molly. Thank you.
All right. Thank you, Maulika. So thank you, Suman, and thank you very much, Atal Innovation Mission Niti Aayog, for giving me this opportunity. So shall I share the screen? Yeah.
Yes, please do.
So I hope my
Yes, it is.
Can you see the screen? Yeah, all right. So welcome to the last and final session of my very favorite program, Student Innovator Program. And I have been part of this program since 2018. Being a startup ecosystem enabler, I have been to many schools, many institutions, higher education institutions, where I used to interact with most of the students and faculty there. And whenever I ask them, what is your idea? The only question they ask is, sir, I will tell you separately this idea. Separately, you can tell it now itself. So everyone has the fear of what if someone steals my idea? Okay, so that's where the intellectual property rights of today's session is very, very important on how you can protect your idea legally. And also, so I will be deliberating on what are the next steps you have to take care after this immediate session. Okay, so there are exciting updates you're going to listen at the end of this session. I request everyone to please be online. And yeah, I'm from Atal Incubation Center, Sri Krishna Deva University, Anantapur, Andhra Pradesh. So now let us understand what is intellectual property. So we usually call it as IP. And there is a law, and every intellectual property, we can protect that intellectual property. Okay, so and we are calling that right as intellectual property role. And what makes it difference if you protect your intellectual ideas, innovations, or designs, whatever it is it going to give a big advantage to your innovation, or is it going to give a big advantage to your business? What will it do? Okay, so today what I am going to do is I will be walk you through the basics of intellectual property rights and why intellectual property rights are very, very important, and then the types of intellectual property, and also I will be guiding you what kind of differentiation this IPR will bring to your innovation and businesses. And also, I'll be giving you some deliberation on what is the procedure to claim the intellectual property or apply the intellectual property, be it different types, whatever the type you want to do it. Okay. And also, I'll be guiding you what are the next steps after this SIP program here. Okay, so now coming to intellectual property, the core definition lies here. Okay, so intellectual property is a collective term for various intangible assets born from human creativity and innovations. In single word, we should say intellectual property is the collective term that is used to protect the human intelligence. Okay, so that is very, very important. Whatever the intelligence you are, that is taking birth from your brain. So that may be innovations, that may be artistic works, or that may be names, symbols, logos, software, designs. Okay, so you can protect all this legally. Okay, so and you will be having exclusive rights regarding to this. So that way, so intellectual property will always give you the competitive edge, the brand value, and also the growth for your for your businesses. Okay, so, so why intellectual property is very crucial for businesses, especially the startups. Okay, you can see there are two images here, a business without intellectual property and a business with intellectual property. So where you can see a business without IP, where there is no protection for your ideas, anyone can copy your innovation or the process of your business so that multiple businesses can evolve with the same idea. So what happens? Your profits are going to share across the businesses. So definitely, what if you have your IP? Okay, then you will be having the specific brand and you are protected by law, and also the revenues will go high because you are the single player in the market for this business and idea. Okay, so that's why it is the superpower that any company or any individual can get through this IPR. Okay, so we will see more examples, okay, about IPRs and uh, how it helps the businesses also. Okay, without IP, okay, so I'm calling a startup is just a business idea, a conventional business it is if you don't have the patent or IP. Okay, and if you have this IP, then it becomes a technology driven business. And also, if you have, you can see the differentiation between startup without IP and startup with IP. Startup without IP, you cannot establish uniqueness because everyone will copy your business idea, technology, or the processes. So, and moreover, your company valuation will not increase if you don't have the IP. Okay, so that one way to increase your valuation if you get the IP. And also, no investor shows interest in putting money to your company or startup. Okay, and also there will be no competitive edge if you don't have the IP. With IP, okay, you will have all these advantage. Okay, you will be having your own unique selling point. You can attract the investors. You'll be having the competitive edge, and also your startup valuation keeps on increasing with this intellectual property rights because intellectual property right is also an asset for the startup businesses. Okay, I'm sure that most of you will start your businesses maybe after the student innovator program, maybe down the lane in the next 3 4 years. So now let us focus on the types of intellectual property rights. Okay, if you see the types of intellectual property rights, we have patents where we can protect the technologies, the innovations, product, or the processes. Then the second thing is we have trademarks where you can protect the brand names, logos, symbols, names. And coming to the copyrights, if you are working on some artistic work, okay, if you are composing a song, if you are writing lyrics to your song, then definitely you will protect under copyrights category. Then we have industrial designs. We usually call it as design patents. Okay, so where you can protect the aesthetic or the visual designs of products And also the fifth category is geographical indications, GI, where you can protect the products or innovations which are region specific. For example, the Darjeeling tea is one thing, and also Kanchipuram saris is another thing, Dharmavaram silk is another thing, and there are 80 Koppikar toys are there in Andhra Pradesh. Okay, Kondapalli toys are there in Andhra Pradesh. These are all geographical indications, and these are specific to the region, those places. And the sixth one is trade secret, trade secrets. Trade secrets are nothing but the confidential business information, like the formulas, processes, recipes. If it is a food-based business, so these are six types of intellectual property. I will also again walk you through the types of intellectual properties. First one is patents, second one is trademarks, third one is copyrights, industrial designs, geographical indications, then trade secrets. Now, to understand each and every type, let us delve into some examples, okay, so that you can understand it very, very easily. Okay. Now, first, what I will do is I will walk you through the definitions, and then I will give you an example so that it will be very easy for you to understand. These are the most common types of protection for any product, process, or design. Okay. To qualify for the patent, there are three basic requirements. The first basic requirement is it should be novel, meaning that it should be you are inventing it for the first time. That means there is no previous existence of what you are inventing. That is what novelty means. The second important qualifier is the invention must be non-obvious. That means whatever the invention you are trying to bring up, you are trying to design or generate, it must be the significant improvement to the existing technologies. That means you should provide a wonderful benefits over the existing product or existing designs, to whom you have to give that significant benefits to the consumers, users, or customer segments. Finally, the third qualifier is finally the proposed invention must have the customer usage. When I say industrial use here, that means the customer usage. It must be usable by the customer. If it is not usable by the customer, that means the solution or the innovation market fit is not happening, then it is whatever you do, it's like a waste of time you will be doing. Okay. So these are the three important qualifiers. One is novelty, second one is significant improvement, third one is the industrial use. Okay. So next, where it came all from. Okay. Patents can be granted under the patent article, and there is a process for this called process, and the term of patent is granted for 20 years. If you are applying for a grant in India, then you will get that grant for up to 20 years. That's it. So for 21st year, if someone comes with that technology, then it will be granted to the other people. Okay. You can, okay. So the second thing is, I'm also giving you the knowledge of the patents are country specific, nation specific. Okay. For US, we have US specific patents. Japan is also having specific patents. European nations is having specific, patents for their specific, locations. So you can prevent others from commercially exploiting your innovation without your consent in other nations also. I have a couple of startups where their innovations have patented in European nations and Japan as well. Okay, so one startup is Helen Bikes. So they are into the futuristic, fully electric e-bike development, and they have design patent and technology patent. They have India patent granted, and now they applied for European nations. There is another startup called Avantech Innovations. So this startup has the Japan patent. Recently, they got granted. So these are a few examples I'm giving here. Then coming to the under patent, we have design and utility patents. Okay. First, let us talk about the utility patents. Utility patents will protect the utility or the functionality of the innovation or invention. Utility patents may be granted to the products or processes depending upon the subject matter of the invention. It may be the product innovation or it may be the process innovation. The process may be while you're developing the product, there might be the process. For that process also, you'll get the patent. Or in your business process also, if you're, uh, reaching out to your customer in a different way, okay, then you can also patent that one. Okay, so we usually call it as utility patent of this one. Then coming to the design patents, these are more on aesthetic kind of thing. So if which covers the aesthetic aspects critical for devices where form impacts usability. Okay, you can see a few examples here in the design patents. The bottle and the perfume bottle, you can see here the two different things. And if you are coming up with the design patent, you should make sure that it should be clearly evident that it is giving some kind of advantage of holding the bottle or spray here. These two examples. If you see the Coke kind of bottle here, okay, so it is very easy to grip it. That is what the design patent is all about. Because this is giving benefit to the customer that so you can hold it clearly and you can consume the product. And then the other bottles, the spray bottle. Okay, so then the product patents. Let us talk about the product patents. One second. Yeah. So coming to the product patents will protect the tangible final or end product and prevent others from making, using, or selling the specific product. Okay. So example, okay, which is a anti-diabetic drug. Okay, so it is granted to Merck in India company. Okay, and it is specific to that particular company. If anyone wants to do this, they can take the technology and they can use that. Okay, they have to take the permission from Merck in India. Okay, and the very famous technology, I should say, here the Samsung India has patented the device unlocking method, the pattern unlocking method. Okay, so you can see on the screen. Okay, so this is again patented by Samsung India. If anyone wants to use this, they have to approach Samsung in India and they should get permission from the Samsung India. These are the two tangible product patents, I should say here. Okay, what happens if you patent the products? It safeguards novel inventions, ideal for new diagnostic tools, imaging devices, or integrated hardware, whatever it is. Then let me talk about process patents. Process patents are very, very, I should say, critical things. Okay. So most of the people will think that the processes may not get some kind of, exclusive rights for this. Yes, we do get the exclusive rights, patent rights for processes as well. Okay, so where you can protect the process for unique manufacturing methods, or you can protect the specific method or the number of steps you are using. Okay, uh, the total essence is about protecting how it's made and not about the final product. Okay, so here I'm showing you the two examples. So one is MJ patent for process and system for efficient biodiesel production. Okay, so whatever you are seeing in the picture, the middle, it is the process and the system where they have developed this biodiesel. And then the very famous Tata salt. Okay, so the Tata Chemicals has patented the process, and here they have patented the process of iodized double fortified salt with more iron. Okay, so where it provides more than 25% of your daily iron needed. Okay, because salt is a very crucial part in our food, in Indian food specifically, right? So these are the two examples for process patents. Then coming to the design patents. So design patents, I'm showing you two examples here. Okay, if you get or if you are granted with a design patent, then you will get all these details. Okay, if you are if your design is very unique and no one to copy that design, then definitely you should patent you should get patent for your designs. Similar to that, our one of our startup got patent for their unique designs, the hubless and spokeless vehicle, the wheel. Okay, and recently Motocorp has requested that design with my startup also. Okay, if you get the grant of this design patent, then you will be having design number, then we'll be having the date. Article name means the design name. Okay, so what is the design? The first one you are seeing here is an electronic walking device for physically challenged persons. Okay, and there are different classes for designs also. Okay, so this comes under the class 03-03 umbrellas, which are like using for you can take it when you and it is for your comfort. Okay, under that category you will get the design patent. Then the second design patent is, okay, you can see it is a fire detection and prevention device. It is similar to your wireless temperature measurement device for humans. Okay, so you can just hold it and you can detect the fire, and also it can prevent the fire. And the class of this one is 29-01. It comes under devices and equipment against fire hazards. So you may ask, sir, who will decide these classes? I will tell you during the application process of this one. Okay, then let us discuss about the trademarks. A trademark might be a simple word, okay, so where you can take it for, a phrase, okay, name, design, or any combination that distinctly identifies your products or services. For example, I will give you a classic example here. So here in the top right corner, you can see the Atal Incubation Center, Sri Krishna Deva Raya University. On the top, you can see the R symbol. That means our logo is trademark. We have registered the trademark. Okay, and we got granted also. So that way, we have few more examples. McDonald's, Coca-Cola. Okay, so they have trademarked it, and still it is the classic example for most of the trademarks examples. Okay, the Coca-Cola is on in its name and also in its shape of the bottle. Okay, where you can hold it within even a child can hold that bottle. Okay, so that is their trademark, the shape of that one. McDonald's, you have the symbol, the M symbol, and also the slogan. That means the tagline, McDonald's, I'm loving it. So that is the slogan. They got this trademark. And then recently, the logistics company Orange, so they took the trademark for the color. Okay, so what happens if you do all these things? So it will definitely give you the brand visibility. And wherever you see this yellow M shape, definitely you'll think of, yes, so McDonald's is there. Okay. So the trademarks not only differentiates your offerings in the market, but also safeguards against consumer confusion and counterfeiting. Okay, because more duplicates you can find in market today. Okay, so for Nike you can find Mikey. Okay, so for Reebok you can get another name also. This is called counterfeiting. Right. So coming to the trademark types, we have three types here. Word marks. So it is just the name, and also sometimes it may be the slogans also. Then we have device marks, where It covers logos, icons, and also some design elements as well. Then we have marks. Okay, it is for non-product businesses. We usually take service businesses. Okay, so I'm throwing you a few examples here for word marks. Coca-Cola is one thing, Yatra, okay, Burger King, Fruity. This all comes under word marks. Then device marks, logos and everything. You can see Nickelodeon, Orange, Vodafone, all these things. The service marks, you can see the Facebook, Skype, Yahoo, all these things. Okay, so which provide you. And also, when it comes to the slogan, okay, so there is a famous slogan for one of the um, scooter company. So where in our childhood, we used to see a lot of ads in DD National. So the company name is Bajaj and the slogan is Hamara Bajaj. Okay, they have trademarked that Hamara Bajaj. Okay, so these are few examples. So then why we have to trademark? What is the importance of trademarks? Okay, so the importance of trademarks lies in these five aspects. One is brand recognition, and you can legally protect that no one will use your brand. Okay, so and you'll get the trust from the customers when you are rolling out businesses, big businesses, definitely. Then business growth and the competitive. Well, coming to the trademarks, I'm taking one use case study here. Okay, so this is Indian use case study. Okay, the Wow Momo. If you see the brand and the design of the total shop, if you see it appears like it is some Chinese shop. Okay, so this is like a little boy who built 100 crore business, a food startup, with just 30,000 rupees. Okay, and that startup name is called Wow Momos. Okay, you can go Google it and Wow Momos. Whenever someone says Wow Momos, then you will get this picture of this, Wow Momos shop, design, logo, everything into your mind, similar to the McDonald's, KFC kind of things, right? So that is the power of trademarks. And what is trademarks? What it will do? It will protect your brand through trademarks. Okay. So branding is very, very important when you are developing your businesses. Then the next segment is copyright segment. Copyright is the protection of original creative works like the software, music, songs, lyrics, blogspot, or poem. Okay, artistical. It doesn't protect ideas themselves, but rather the expression of those ideas. Okay, so if you see most of the slides or the programs that AIC Sri Krishna Deva Raya University has designed, we have copyrights on our programs design. Okay, we have a Ignite program, which is entrepreneurship development program specifically to the rural and small town students. And also we have a bridging program, pre-incubation program called Vantena, which is again the copyrighted program designed by AICSKU with curated syllabus and methodology as well. Okay, which is a 100 days pre-incubation program. These are all copyrights that AICSKU holds. Okay, and uh, so you might be seeing the copyright, all rights reserved, and also a few companies they will be keeping copyright, the symbol, and then the year. Till that year, we are holding these copyrights. Okay. So then coming to the copyrights, what are the various categories under the copyrights? Okay, so you can copyright the literature work, you can copyright the artwork. I mean the pictures you draw, you can copyright it, or the literature, whatever the book you write or whatever the novel you write, you can do that. And also the cinematography, the movies, you can copyright it, and the sound recording, whatever the sound recording, if you have your own voice or you are singing your own song, then you can copyright that one also. And then uh, your composing in music is also can be copyrighted. Then the drama, it should be of your own thing. Okay, the characters, designing of the characters, and then behavior of the characters, whatever it is, dialogues, how you're portraying that characters, everything you can copyright. Okay, few of the examples I'm putting here on the right side, the Harry Potter, and then the Beatles, and then of course the Windows, the software. So coming to the importance of copyrights again, so it prevents copying. Okay, if you are not copywriting your software, your operating system, then definitely someone will take that and they will use it. Okay, so that's why they will keep licensing part for Windows or any other part. So then it builds market value and it protects creative assets like the composing your music, lyrics, code, everything. And moreover, it attracts investors. That means investors will understand how serious you are in protecting these, in protecting your work. Then definitely they will come back and put money to your company. Then I'm giving you one use case here, the famous T series. And this T series has shows that the copyright can turn the creative work, composing music, movies, everything into billion. Okay, so especially in content-driven businesses, so cinemas, music, software, e-learning, everywhere, right? So there's one use case study. Okay, then let us talk about trade secrets. So trade secrets are very, very important techno-legal rights to protect confidential technical information of any product or process or technology. So here I'm taking the examples of Coca-Cola and KFC. If you see the KFC, so the trade secret of KFC is it is using 11 herbs and spices to bring up that flavor and the taste of that kitchen. Okay, and the trade secret, it is the trade secret since 1930. Okay, and then coming to the Coca-Cola, the trade secret of that combination, the formula, the process of manufacturing, and the trade secret is since 1880s. Okay, trade secrets where no one, will copy your recipes or the processes. Okay, and it has the step-by-step procedure. Okay, where you can how you can do what are the ingredients and what is the step-by-step procedure, how much time it will take for each and every step, what are the ingredients we have to add. So every part will be there. This is a kind of more informative, technical information, I should say. Okay, so that every company wants to protect. And recently I have listened one case in US where so one of the guy he has taken the trade secret. I may not mention that as trade secret, but the recipes of some Indian uh, samosa and the snack items, especially the pops. Okay, the spicy pops. uh, she went to the lawyer and she got that back and she claimed around 7,000 US dollars of their profit for this. Okay, that is the power of trade secrets, right? So then, so when you have to protect your trade, your trade secrets, rather than securing the patent, first you protect it as a trade secret first. Okay. So patents are disclosed to the public by inventors and provide protection for 20 years only. Okay. In contrary, trade secrets are not disclosed. Okay, to any public, no need to disclose, and can be protected as long as possible. Okay, there is no limitation. That is the difference between the patent and the trade secrets. The trade secrets are not advisable for longer term protection or where the product or process can be easily reverse engineered by the competitors. But yeah, so they can be copied through reverse engineers, but fine. So they should come up with the different flavors or different kind of mechanisms, but they should not copy whatever already that there is in the trade secrets, they should not copy. Then yeah, coming to revision part, and also the term of the type of IPs. If you see, the patent is for product, process, technology, and invention, and the term is for 20 years. Coming to the trademark, it is for brands, name, word, logo, symbol, image, slogan, sound, lyrics, music, whatever it is. So then it is for 10 years and can be protected indefinitely on payment of maintenance fees. The trade secret, very, very confidential information, technical confidential information. So it is indefinite. There is no specific term for this. You can protect your confidentiality. Then coming to the copyright, so literacy work, then dramatic, musical, and cinematography works, sound recordings, everything. You can, the term might be up to 60 years. Then, so now the important point is how I can, what is there in my idea? Okay, if I implement my idea, is there a patent in my idea, or is there trademark in, or what is that secret I should kept if I do, or if I do a innovation? Okay, here is an example I'm taking. Okay, a scenario is a general scenario. Okay, if you are a student, a unique herbal energy drink, and if you have created a special logo and packaging as well, and if you have a specific recipe or formulation and that is very secret, no one knows that, and if you have a specific bottle design, a very stylish and distinctive in colors and holding it, whatever it is, and if you want to expand it globally, okay. Now the question is, sir, I'm doing this work and this is the scenario we are taking an example. Okay, what type of IPs that should be used for this particular scenario? Let me take you. You can take it, okay, because you have a utility patent for the invention of the process, because the drink, the trademark for logo and the brand you are creating here, and the trade secret for recipe, and then industrial design for the bottle shape, and then the copyright for advertising content. Okay, so these are the things you can just focus on your, in this scenario you can focus. Then how to identify IP strength of innovation, of your innovation. Okay, I'm just putting you a few points here so that it will be easy for you to spot the IP strength, okay, in your innovation. For patent, what is required? Novelty is required. So no should have ever done that one. So then that is called novelty. Then there should be a inventive step. That means a specific advantage or benefits you are giving to the, then you can patent it, and it should be capable of industrial application as well. Then you can patent it. If your innovation is of any of these three types, if it is novel, you can patent. If it is having inventive step, you can patent. If it is having industrial application, you can patent. Then coming to the copyright must be very, very old. If you have the original work only, you can copyright it. Okay, you can see the pop songs. Pop songs are very, very original things no one could have done before. So that can be copyrighted. Then trade secrets. You should not be disclosed anything. So then you can, do that as trade secret. Then coming to the design patent, it should be the original. Okay, so you can see the Viva company has this reverse squeeze bottle. Okay, so that is their design. I don't know whether they have patented it. So then coming to the semiconductor integrated circuits layout design. Okay, so what are the requirements? The originality, distinctiveness, capable of distinguishing from any other layout design. Okay, especially when we talk about semiconductor IC layouts, we will be talking about computers, smartphones, application specific devices, all these things. Then plant variety and farmer rights. So if you have novelty in the plant varieties, you can go for uh, patent. And then distinctness, uniformity, and stability. Then coming to the geographical indication, identification of the goods and its particular area of geographical origin. Okay, and you won't find anywhere else in the world. So for that matter, we have Araku coffee, which is very much available in Vishakhapatnam region or in the Araku Valley. You can find it. So that is patented under geographical indication. Then we have trademark. Okay, so the trademark should be distinctive and non-deceptive. Okay, so to spot the IP, these are the requirements you should have, you should possess. And for checking the patentability, it must be new, novel. It must involve an inventive step, as we discussed in the earlier slide. And now, let me walk you through the filing process, and I will also tell you the importance of drafting and claims. So now, the first step in filing the patent is, I should say, pre-filing public disclosure is very, very important. If you want to patent something, a process, a product, okay, then you could not have published it or disclosed it with anyone. That is very, very important when you want to file the patent. Okay, that's why we are calling it as confidentiality prior to the filing. So pre-filing public disclosure can destroy the novelty of the invention. Okay, so you should keep everything confidential prior to the filing. That is very, very important. Then coming to the filing process, few steps here. Okay, so let us assume you have an invention. Okay, an idea or invention or a design or a process, whatever it is. Then what you have to do is first you have to check the patentability. Okay, so whether this is we usually call it as patent search. Okay, so whether uh, invention is patentable or whether your invention is novelty, we need to check before we draft the patent. Okay, that is the first step. The second step is you have to draft the patent. You have different steps in patent drafting. My suggestion is to all the participants, if you want to patent and if you want to draft, try to get in touch with IP lawyers or IP attorneys so that they will help you in drafting the applications. Okay, and then the third step is filling the application. Okay, so fill very, very, the crucial part. Okay, because there are necessary steps we should follow while filling the application. Then the next thing is whatever you have filled, then the portal will publish it. Okay, that is what publication is. That is the next step. Then your application will get examination. If there is any obligations or objections from any of the people, you'll be having some time after publication. Okay, so then someone will give objections for that. If you get the objection, then you should go and defend your application. Okay, it may be single time you can get that, or 2 times, 3 times you can get. And one of my startup got 4 objections that way, 4 times objections. And in the fifth hearing, they got this patent grant. That is the final step. Okay, so these are the brief steps I am putting here down. Okay, so invention is the first step. The second step is to search for the patentability. The third step is patent drafting. The fourth step is filing the application. Fifth step is publication and wait for examinations. Okay, or if there is any objections, you should go for the hearing, or your IP lawyer can go for the hearings. Then finally, after all these things, you will get granted the patent. Okay, So this is in-depth analysis, but I don't want to put this in-depth analysis to you here. Okay. This is also somewhat in-depth. Yeah. So I just want to put you, the types of applications, patent applications. The ordinary application, if you are going and filing it, there are no timelines, and as and when ready, you will get that. And the term of the patent is 20 years from the filing date. Then the conventional application, within 12 months of first filing date, you will get the grant. So, and again, the term is 20 years. The PCT, the provisional national phase application, within 30 months of first filing date, you will get the grant. Then divisional patent application, before grant of application, this is the timeline, and then up to 20 years from first filing date. Again, the term is same if for the patent addition. Okay, so any time within span of parent application is the timeline, and then the term is leftover term of patent application. Okay. Then the structure of the patent, simple, you will be having the title, the description, claims, drawings, and abstracts, the structure of the patent. This will be the structure of the patent. Whenever you're applying, keep that in mind. You'll be having title, description, claims, drawings, and abstracts. The patent, the granted patent, you will get this way. So now I told you that the strong drafting is very, very important when you are applying for the patent. Okay. When your drafting is strong, then you can protect it very, very strongly. Okay. So let us take one and Sanofi and Reach. So Amgen patented a a monoclonal antibody targeting. Okay, so to lower the cholesterol, that was their invention. The claims focused on functional aspects rather than exact sequences, whereas Sanofi and Regeneron challenged the validity of patent due to insufficient patent description. See, this is what happens. Because Amgen has not given enough description, then they have challenged this. Comes at the stage of, objections. After publication, you will get this phase. Okay. Here, what happened? Amgen has filed the patent. Sanofi and Regeneron challenged the validity of the patent due to insufficient patent description. Then, so that's why the strong protection of your idea will come from strong drafting. Okay, so this is another case study I'm putting here. Okay, Monsanto's Zipsoport patent. Okay, so where this company patented the herbicide glyphosate with claims specially covering its chemical structure and agriculture use. Okay, its clear and enforceable claims aligned with commercial goals, facilitated long-term market control and profitability. So their patent, the strong drafting is very, very important, right? I think this is more into the startups thing. I don't want to get into the startup thing. Okay, this is one startup where they have protected their patents. Miramai is the India health tech startup. Okay, they have their thermal imaging plus AI algorithms for early breast cancer detection. Okay, it's a women-led startup, and it took a non-invasive and affordable innovation, and it made globally scalable. So wonderful platform. I think after this session, startup. Then another one is Gray Orange. So it is a robotics company startup. Okay, so where they have patented warehouse automation robots. Okay, so they use this butler and sorter systems. Okay, so they are from a small Indian startup supply chain market. That's what their thing. And the impact is their patent backed robots are now deployed in Flipkart, Amazon, and most of the international warehouses. And yeah, for us, okay, so because time is running out, I'm just keeping it short here. Then yeah, so far, what we did is, so we have orientation of student innovator program. So where this happened on 28th August, setting the roadmap, and then you had also experience with the design thinking workshop here. Then the first week of the September, you have you had two sessions. One is you have refined your problem statements and prototypes, and in the third September, product development and POC you have completed. And 8th September, the second week, so the target market value, branding, building website, business cards, all these things you have done. And finally, today, 11th September, how you can protect all your work, all your ideas is what we have discussed here. And yeah, right. We should also discuss about the next step, the most exciting part. The most exciting part here is, so now Atal Innovation Mission will roll out another application form where the shortlisted student teams will get 1 week boot camp at different incubation centers across India. And then Atal Innovation Mission, in partnership with AIC SKU, is also giving you another opportunity where your innovations can put on the global platform. And that global platform and the recognition, international recognition, ICIA, International Creativity and Innovation Awards for 2026. AICSKU, again, Atal Innovation Mission, we have been taking many student teams to these platforms since 2024. First, we took them to Thailand, and the second, Vietnam. And this year, we are planning to take few student teams to Cambodia, okay, which is a big platform where more than 30 plus countries participate. It's a huge stage, and I think I request most of the students should participate this program. And also, so what is the next process? You have a good idea, and you have training through Student Innovator program, and also you will get 1 week boot camp from the incubators. Now, what next after successfully completion of Student Innovator program as well? We'll be having Student Enterprise program. Okay, so it is a purely enterprise development program. So again, Atal Innovation Mission will spearhead that program. Then what we can do? Okay, sir, we have idea, and now we have generated a innovation also. Now what we can do? Throughout this session, I'm deliberating that you should protect your idea, protect your innovation. What you have to do is you have to patent your innovation, then it will become technology. After becoming technology, what you can do is you can transfer your technology and you can get the monetary benefit. Okay, sir, I don't want to transfer my technology. I want to do business with that technology. Then what you can do is you can start your own venture through a startup business. Okay, so first one is a student innovator program. After completion, 1 week boot camp at incubation centers. Then international recognition at ICIA 2026. Then enterprise development program, and then patent, technology transfer, and then starting up your own business. Okay, so that's all from my side, and a small tour of AIC Sri Krishna Devaraya University, Anantapur, Andhra Pradesh. So where most of the innovators, student teams like you came here and worked here. Uh, and yeah, so thank you very much. Namaste to all of you. So do visit our incubation center whenever it is feasible to you. If there are any nearby schools in Andhra Pradesh, please do visit Atal Incubation Center. I will give you the opportunity to interact with my startups. I'm sure that you will really, wonder the kind of innovations you see here. To Atal Innovation Mission Niti Aayog for giving this wonderful opportunity. And I'm looking forward for more such programs. Thank you, Suman and Maulika.
Thank you so much, Dr. Molly, for a very, very insightful session. I'm sure the children learned a lot about intellectual property rights, about the various types of intellectual property rights that they can do, the difference between patent, copyrights, trademarks, very, very important things that they need to understand at this point. So thank you so much for that session. Thank you so much for doing a recap of the session. We did go through design thinking, then we refined our problem statements, then we understood what are prototypes, then we understood MVPs, and then we understood the market, the branding, and how we can build our own website. How do we project our organization, our startups, our products, and of course, the intellectual property rights session today. So now we are coming to the end of our Student Innovator Program 2025, but this is not the this is not where it all ends. Actually, you have a very exciting opportunity to showcase what you have learned and put it out there through our Google form submission that you have to do by 30th September. आपको ये 30 तारीख तक ये फॉर्म भरना है, जिसमें आप अपना बिफोर कैसे था प्रोडक्ट और आफ्टर आपने क्या इम्प्रूवमेंट्स किए हैं, क्या अपग्रेडेशंस किया है, वो सब डाल के आप आफ्टर आपने क्या किया है वो डालेंगे. And you are going to also answer if you want a 1 week mentorship about. If you're interested in that 1 week mentorship, I will just quickly walk you through the form so that you understand कि कहाँ पे क्या करना है. I'm going to share my screen for this. Right. So it's a very, we are going to just quickly go through. First of all, you have to write your Student Innovation Marathon ID. Then you have to write your school name. Then you have to put your UDICE code. Then you have to put your ATL code. Of course, if you are from a non-ATL school, put NA. You have to put your district. Then you have to select your state name. You have to write your team name, team member names. Okay, this is very important. Then to write your innovation title. The most important thing, what have you come up with? Then you have a link, then you have to add the link of the video submitted during the Student Innovation Marathon. जो आपने तब सबमिट की थी, वो वीडियो लिंक आप यहाँ डालेंगे एंड आप डिस्क्रिप्शन डालेंगे कि क्या था, what is the type about. Then you will put the link of the after SIP, after going through the Student Innovator Program, आपने क्या क्या सीखा, उसे कैसे अप्लाई किया, उसके कैसे अपग्रेडेशंस किए, how did you upgrade your prototype to become an MVP, or if it's still a prototype but it's improved from before, put that. That is very important. The video has to be 1 to 2 minutes max. Okay, show what has changed and why it is better now, very important. Then you have to put a description of your innovation. What is your innovation now? Okay, tell us what you have improved, what is different, what feedback you have received, what evidence do you have. All right, and then you have to uh, talk about, then you have to answer if you want that 1 week mentorship program with the incubation center and our partners, our expert partners. If you want that 1 week mentorship, you have to answer if it's a yes or a no. And if you have added yes, you have to tell us briefly why do you need this mentorship, what are your plans for further requirement, like what are you going to do, how are you going to improve it, why do you need this mentorship, how will you take it forward, right? So you have to write that. give your plan, your action plan for the mentorship. And then lastly, of course, add your teacher's name, add your teacher's email ID, add your teacher's phone number. And this is the form that you have to submit. Okay. So, very quickly, I would like to now come to the end of this session and tell you that we have had a very wonderful journey so far. We have learned a lot, but now it's up to you. You have to make the difference and you have to bring out the best in you and show what you can do. So now you have to pull up your socks, do well, bring on the best, and have a lot of fun doing it. Okay? Thank you so much for being part of this session.